affidavit and all the bundles that were forwarded to us, and we are also in a consensus that we
to address you. We have met with you this
of argument. I want to briefly deal, if I may, members of the tribunal, with our submissions in respect of the first complaint. In respect of the first complaint, there can be no doubt that the respondent was chairperson of IBOC during the period 1 January 2018 to the 16th of March 2018. And that she was a judge of the High Court with effect from the 1st of January 2018. The evidence is unchallenged that the President appointed her as a judge on the 2nd of November 2017 with effect from the 1st of January 2018. And this was communicated to Judge Makhubele, not only through the media, but through emails from the Judge President, being Judge President Mlambo. As early as the 4th or the 5th of October, the Judge President had communicated to her that she was a success. And he later confirmed this in his directive of the 19th of October 2017, congratulating her on her elevation as judge permanently, and I underline that. This was confirmed in his email to her on the 6th of December 2017. In the preamble to setting out the facts, we as evidence leaders referred to these emails and they appear to be common cause. The respondent must have known at least by the morning of the 5th of October 2017 that the Judicial Service Commission had recommended that she be appointed as a judge. According to the Judge President's unchallenged evidence, he informed her himself that she was successful. It is our respectful submission, unfortunately, we are compelled to make this submission. Judge Makhubele was a thoroughly unsatisfactory witness. She would have this tribunal believe that it was not a foregone conclusion that once the Judicial Service Commission had made a recommendation, she was destined to be appointed permanently as a judge of the High Court. She resorted instead to giving testimony, relying on the fact that Madam Justice Meyer had not been appointed as the Chief Justice, despite the recommendation of the JSC to the President. It is our respectful submission that Judge Makhubele's provisions or understanding of the provisions of Section 174, at best for her, should be found to be wanting. At worst, it is our submission that the inference is inescapable that she resorted to this excuse, amongst numerous others, to explain away her failure to assume her duties as a judge when she was duty-bound to do so. By contrast, we submit that Judge President Malambo's evidence was clear and satisfactory in every material respect. There's no reason to reject it. And from the summary of his evidence, his version was not challenged in any respect whatsoever. The instructions put by counsel on behalf of Judge Makhubele were not aimed at calling into question the reliability or the credibility of the account which he gave. On the other hand, we submit that the respondent gave evidence which in material respects differed from the Judge President's version, and these include the following. Judge Makhubele testified, 1, the evidence of the Judge President that he called her in to take the oath in January 2018, which led to the meeting with him and the Deputy Judge President, Mr. Justice Ledwaba, in the second week of January, was not true. I underline that. Second, there was an agreement in place between herself and the Judge President as far back as June, July 2017, that in the event of her being appointed, that she would commence her duties only on the 1st of April 2018. 3, the Judge President informed her on 15 December that her appointment was invalid and that she was returning the appointment certificate to the minister. He was returning the appointment certificate to the minister. And then finally, her meeting with the Judge President and Judge Ledwaba only took place in March 2018, when it was agreed that she would be allocated recess duties in April of 2018. Now, not one of these disputes of fact, which were differed toto kailo from the version of Mr. Justice Mlambo, were put to Judge Mlambo when he testified. In view of the failure to challenge this evidence, and it's on record, the evidence leader decided not to call Judge Ledwaba. However, it is patently clear that had Judge Ledwaba been called, he would have testified according to the version set forth in his affidavit to which he had deposed. The respondent was unable to account for why these two senior judges should falsely claim that the events of January 2018 had taken place. We submit that on any objective view of the events as they unfolded, the respondent's claim that she only had a meeting with the Judge President after the 26th of January 2018 and not in the second week of January 2018 ought to be rejected based purely on the probabilities. The Judge President had made it patently clear to her in his email of the 6th of December 2017 that the appointment had been made with effect from the 1st of January 2018. With that in mind, the Judge President sent a draft duty, or caused a draft duty roster, which is to be sent on the 7th of December 2017, which included duties being allocated to the respondent during the first term of 2018. That is further confirmed in our respectful submission by the email of Offense Khumani. My Lord will, Mr. President, will recall that she was to be the witness who was to support Judge Makhubele's case. The email in question from Offense Khumani was addressed to Judge Makhubele on the 21st of December 2017, which included a comprehensive list of her duties for the first term. There is no evidence that the respondent responded to this email to the Judge President or Ms. Khumani. The tribunal was told that Ms. Khumani was to be called in support of the respondent's version, and she was not called. The inference is inescapable that if called, she would not have supported Judge Makhubele's account of events. What is not sufficiently clear from Judge Makhubele's version is why, having been informed on the 15th of December 2017 that her appointment was invalid, that the paper's certificate was being returned to the minister, why in those circumstances the Judge President would have done a volte-face to include her in the final roster for the first term within days of this so-called meeting. The tribunal would have to be driven to conclude that the Judge President verily believed that a recommendation of the Judicial Service Commission meeting at which he was a leading participant had resulted in an invalid appointment. The respondent's version of events also fails to account for the letter by the Judge President to the Minister, which he sent on the 22nd of January. According to the Judge President's unchallenged evidence, it became clear to him that the respondent, Judge Makhubele, was not prepared to do her work. The Judge President was thus under an obligation to approach the Minister not only to mitigate the effects of her failure to report, but to make alternative arrangements for acting judges to be appointed to take over the duties which she would have been required to perform. Under questions from the tribunal...
May I just interrupt you there, sorry? On that aspect, the fact that when Judge Makhubele did not commence judicial duty on the 1st of January 2018, and when it had all happened, Judge Mlambo took the initiative to write to the minister and to try and extend the date of appointment. And you'll also recall that I asked him, that is Judge Mlambo, when he was here, that shouldn't he have taken the matter rather to the JSC? And he said, well, I'm talking about hindsight wisdom or something like this. But the issue really that has been occupying my mind for some time, that fact that when Judge Makhubele did not start on the 1st of January, and letters were written to the minister and other people, there was an opinion sought from somebody about the situation. Can it, under those circumstances, can it be validly argued that she was misled by the judiciary? Can it count in her favor at the end of the day that if the 1st of January was the appointment, that's it, there's nothing else that can be done about it, but they engage in activity of seeking advice, writing to the minister, I don't know who else. Can it be argued that she was misled by the judiciary?
if I may answer that question, my respectful submission is, Judge Mashidi, is that one has to look at the facts holistically. Judge Mlambo was, and the sense that I get from his evidence, was that he was between a rock and a hard place, between Sicily and Charybdis. Here he had, and Judge Mashidi, you will remember how he was being pressed on why he had written this letter and why he took the actions he did. And they were driven by the fact that the frustration that Judge Makhubele didn't turn up for work, unlike everybody else. Everybody else came to work to take the oath, so to speak, and she didn't. And he had to get hold of her, to get her to come to chambers at the Palace of Justice, where he arranged for Judge Tintswalo to be there. And when it became apparent to them that she wasn't prepared to relinquish her duties as a prizer, he had to, he's got a very busy, you remember, Judge Mashidi, that you asked him questions about the question of the workload of that division, and that he was under pressure to act quickly to ensure that that he had judges who could do the work which Madam Justice Makhubele would otherwise have been required to perform. And that's what precipitated the letter. It wasn't what had happened on the 15th. And this is what the narrative that the Judge Makhubele wants this tribunal to accept, that there was already, she wasn't required to turn up for work. Whereas Judge Mlambo was quite clear. She was a judge. She had been validly appointed. According to him, she was a judge, and he expected her to turn up, to take the oath. And when she made it plain to him and Judge Tintswalo that she was not prepared to relinquish her duties at Praza, he had to then get hold of the minister. Yes, I accept, Judge Mashidi, that that what was his actions were to, well, can we make the best out of a mess? Because that's really what it was. It was a mess. And I respectfully submit that Judge Makhubele could not have been under some misapprehension that this whole thing had been sorted out and she could carry on with Praza.
Thank you, but it even went further. At some stage he said to her, here is your certificate with an effective appointment date of 1st of January 2018, but I won't give it to you now. It does not work anymore. And in other words, that certificate was invalid.
Well,
but did not give it to her.
We made the comment that it's somewhat bizarre, quite frankly, that a judge president who is steeped in the traditions of the JSC, and bearing in mind too that if one has regard to the fact that he had created all these opportunities for Judge Makhubele to advance herself, gave her the opportunity when she was junior counsel to act on the bench, the first judge president to do so, and that she had acted for 58 weeks in his division prior to her appointment in January or in November of 2017. It's unthinkable, improbable, grossly improbable that this event, as Judge Makhubele would have this tribunal believe, that this took place on the 15th of December.
And he went on further and said, this is your own making. You remember that email?
Yes. That was the,
when he told us it's your mistake, it's your own
yes.
making.
Yes, that was the email in response to her email of the 4th of December, the email which Judge Makhubele sent to Judge Mlambo. It also happened to be on the same day that she had an interlude with Mr. Mokhashwa, when Mr. Mokhashwa was summoned in relation to the report which had mistakenly found its way to him, and which he was required, he had answered, and she said, I'm not having any regard to that, but it happened on the same day. The so-called meeting with the judge president happened on the day when Judge Makhubele was so engaged in these negotiations and deliberations of Mr. Zide and Mr. Mokhashwa to thrash out a settlement agreement in the CIO case. But Judge Mashidi, I take your point. Why would, I'm going to get into that, why would Judge Mlambo have had such a change of heart from his attitude, as you rightly point out, for his email of the 6th of December in response to her? He said, you know, it's your own doing. The ship has sailed, he was saying. You were appointed. Have I dealt with that sufficiently, Mr. Justice Mashidi?
Yes, thank you very much. I don't want to waste time, but on your first point about the evidence of Judge President Mlambo, and as supported by the affidavit from DJP Ledwaba, in arguing in the manner in which you did, I'm sure you do accept that for us to accept their evidence, it's not the fact that they are senior judges. That alone is not what has to compel us to accept their evidence because of their status.
No, I absolutely, that's not what we're submitting. We're not submitting that by reason of the fact that they're more senior, that they must be believed. It's a combination of how they came across, well, how Judge Mlambo came across as a witness. The trier of fact would have regard to demeanor, which is a tricky horse to ride according to the law, Saul's case, but also to the content of the evidence. And that's why I underline the word probabilities. What are the probabilities? And we have a look at the communications upon which Madam Justice Makhubele relies, which we respectfully submit is utterly at odds with the picture she's trying to present. It, far from assisting her, it to some extent undermines what she is saying. So, yes, in answer to your question, the tribunal obviously has to make a credibility finding. In the matter of Hlophe, the judges found that on the probabilities that the versions of the judges of the Constitutional Court were preferable on the probabilities, rather than saying, well, somebody's not telling the truth as opposed to the other person is telling the truth.
Thank you. I think you may proceed. I interrupted you.
Thank you.
Sorry, Mr. Peva. On this point, and let's just concentrate on the dates that you are talking about now. On the 4th of December, the correspondence to Judge Mlambo and his reply. Now, what I want to know, what to you on your argument, what does that really indicate as to the evidence later given by Judge Makhubele as to whether Judge Mlambo had already agreed that she could start after the 1st of January, if you remember the sequence of events. Why do you say that sequence of events on Judge Mlambo's evidence indicate that Mlambo had never agreed to her starting later? Do you follow what I'm asking?
Yes, I do.
Yeah.
I do.
Yeah.
I do, Judge. We've set out in the preamble. We set out the sequence of events, and I submitted it's quite important because he made it clear. Well, it goes back to the 19th of October. He said, you will remember that Judge Makhubele sent an email to him thanking him, and she accepts the appointment, but she wanted to have a discussion about the starting date. It was left at that. And the Judge President then responded by saying that she, it's her email, it's on page 10 of our, we said, "Dear JP, thank you for your support and recommendation. I'm glad to accept the placement in Pretoria. I would like to have further discussions with you regard to the starting date of my appointment." Then the Judge President wrote on the 23rd, "Thank you for your response. You are not compelled to procure a vehicle, and yes, you can continue using your vehicle. I suggest that you indicate what your view is regarding the starting date by email, as I'm hectic this week. I hope you find that in order." So at that point, there, quite rightly, Judge Japie, there was some mention of a starting date. But then it was quiet. Nothing was said about it for weeks. And then on the 4th of December, "Dear Judge Mlambo, I apologize for taking time to respond to your email below. That is the email of 23 October. I had to do much reflection on the matter, taking into account all the positions that I'm currently occupying. After much reflection and considering every aspect of the challenges, I think it will be in the best interest that I start on the 1st of April. That's the first documentary evidence of that. It was in April, that I start in April of 2018. Before that, there was nothing in writing, so to speak. Then, on the 6th of December, the JP emailed Judge Makhubele, "Hello, Nana. Thanks for your email. The delay has been your undoing, unfortunately. The President has already done the appointment with effect from 1 January 2018. I'm waiting for the appointment letters and certificates. We can meet next week." And then the Judge President promptly thereafter sends out the draft duty rosters, including Judge Makhubele. Then the final rosters go, then Judge Makhubele on the 7th of December says, "Dear Judge President Mlambo, thank you for the email. I've noted the allocation. I request you to place me on hold until we finalize the discussion about my application start later."
So
Then Offense Komani then emails Judge Makhubele, "Here are your files." So obviously, as far as the Judge President is concerned, he expects it to start on the 1st of January. There can be no question that that's what he expected.
So on that evidence, as far as the Judge President is concerned, that is Judge President Mlambo, in December, he was still of the view that Judge Makhubele would start on the 1st of January. You follow what I'm saying?
Yes,
If you look at the correspondence at that date.
Yes.
Now, on the evidences, when does the change occur?
Well, the change occurs after the event which Madam Justice Makhubele denies took place, and that is after the second week, when she didn't turn up for work, when she didn't turn up to take the oath, but instead had to be summoned to the Palace of Justice to meet with the Judge President, so that she could take the oath. He expected her to take the oath at that particular point, and the tribunal will recall his evidence that he asked her, well, why are you reluctant to do, then she mentioned again the water tribunal on that occasion. And it was only after he pressed her about what he'd heard through the media about her involvement with PRASA that she admitted it. And then they tried to persuade her to stop what she was doing at PRASA, and she refused to do so because she didn't want to disappoint the minister. It was at that point that Mr. Justice Mlambo had to make some alternative arrangement to mitigate the problem that he faced as the Judge President of that division.
Well, let me put my question this way, and relating to Judge Mlambo's evidence. When did he become aware that Judge Makhubele would not start on the 1st of January? According to her, if you followed the evidence, he already knew much earlier, according to the evidence given by Judge Makhubele, sometime in December. Now, if we leave that evidence aside, either the evidence given by Judge Mlambo, which is denied by Judge Makhubele, how does one reconcile that? Is it reconcilable? That is my question.
There are two mutually destructive versions. So the tribunal is faced with the issue, where do you decide where the truth lies? Unfortunately, that's the situation we stare in the face in this matter.
Either the meeting in the middle of January happened, or it didn't happen. You can't have it both ways.
Exactly.
Now let's deal with that meeting of the 2nd of January, the second week of January, as testified to by Judge Makhubele. As Judge Mlambo. And what we've heard and what we've seen is an affidavit by the Deputy Judge President supporting the occurrence of that meeting. Am I correct?
Yes.
So, and the evidence leader, because Judge Mlambo wasn't challenged about whether that meeting happened or not, it was then decided not to call the Deputy Judge President. Because as far as his evidence is concerned, as far as Judge Mlambo's evidence is concerned, at the time when he testified, the impression was that that meeting of the 2nd of January, the second week of January, was not being challenged. What are we to make of that? And what inferences can be drawn from that?
Well, we've referred to the authority, and Judge Japie, you and Judge Mashidi are seasoned trial judges. We know what the effect is, that if you don't challenge evidence at the time when it is given and before the witness is excused, then you are taken to agree with that evidence. And one of the consequences we know in dealing in criminal cases particularly is that the argument presents itself that when you lead evidence as part of your own case, which is at odds with what was given by a witness, the suggestion may well be that this is now evidence that is manufactured, so to speak, or And that's the effect of it. And the inference is inescapable. And we've dealt with with the position in the instant case. We're not dealing with a lay person where one could expect, oh, well, he admitted he didn't quite see the importance of challenging evidence. We're dealing with somebody who's steeped in the law, a senior counsel, a judge of the High Court, who hears this evidence being given and yet does not, the inference is inescapable. She did not, Judge Makhubele did not instruct her counsel because at that stage she didn't disagree with it. So that is what we yes. Well, the second issue, of course, is for what possible reason would Mr. Justice, because we can ask that. This is an inquisitorial inquiry. We're not dealing with a criminal case where there is authority that, it's not legitimate to ask a witness to speculate as to why another person should give false evidence. But for what possible reason would Mr. Justice Mlambo have made up this meeting? And not only made up the meeting, but have deposed to an affidavit under oath, being a judge, and Judge Ledwaba being a judge, deposed to an affidavit under oath about something which never happened, and they knew it. This is not a case where they could, when you have identification witnesses, somebody could quite honestly believe that drove into him or broke into his house. This is not, there's no room for honest mistake here. It's either a blatant untruth or it's the truth. Now, it's Judge Makhubele. She repeated it repeatedly, that this was absolutely untrue. This meeting did not take place. This is what confronts this tribunal, to make that kind of credibility finding. I got to the point before I was interrupted where I was dealing with the events of January of 2018. We make the submission that the respondent would have the tribunal believe that it was only the letter which came from Unite Behind of the 26th of January which precipitated a meeting between herself and the judge president. The advent of the inquiries by Unite Behind clearly set out their concerns, which led to the correspondence by SMS, which the respondent claims was the catalyst of the meeting with the judge president, which he says was the first to take place on the 15th of December 2017. However, this version was never put to the judge president. Again, just to put that in context, the tribunal will remember that Judge Makhubele was at pains to say that I have these communications between myself and the judge president. They form part of JM 1, 2, 3, and 4, the bundles which were introduced within a day or two of Judge Makhubele giving evidence. The actions of Unite Behind did not stop at that point, and further correspondence was directed to the President, the Chief Justice, the Judge President, and others on the 12th of February 2018, which made it plain that the respondent was in breach of the Constitution because she was holding office as a judge, as well as serving the executive as chairperson of IBOC. This further complaint, no doubt, came to the knowledge of the respondent. It must have come to the knowledge of the respondent. And if one looks at the timeline again, on the 22nd and the 24th of February, this is now within a matter of days of the unite behind complaining now to the Chief Justice. They had originally just written to the Judge President saying, you know, we just want to draw this to your attention. On the 22nd and the 24th of February 2018, the respondent met with the attorneys from Edward Nathan Sonnenberg, ENS Africa. The respondent, as chairperson of the board of PRASA, commissioned an opinion from ENS Africa on 3 questions. Was the Minister of Transport's appointment of the respondent to the board of PRASA lawful? Was the respondent at the time, late February 2018, a judge? And was the interim board of PRASA lawfully constituted? Now, in regard to was the respondent a judge, we will obviously, Judge Makhubele's version is that these people went on a tangent. There was no instruction to them to opine on these matters. We question whether that evidence of Judge Makhubele can withstand scrutiny in the light of what had previously happened. On the 28th of February 2018, ENS Africa provided its opinion to the respondent. It advised the respondent that the taking of the judicial oath of office is a prerequisite for a judge to perform their duties as a judge, but it is not the determination of her status as a judge. No judge may perform any other office for profit. The respondent was a judge with effect from the 1st of January 2018. Therefore, the respondent may not, with effect from 1 January 2018, perform any other office for profit, regardless of whether she was receiving a salary as a judge. We make the point that the respondent, having received this opinion, which could hardly be said to be in favor of her case, sought to distance herself from the opinion by claiming that ENS Africa had somehow, in spite of 2 meetings on the 22nd and the 24th, somehow misguidedly exceeded its mandate by opining on matters in respect of which its opinion was not being sought. In this respect, too, we respectfully submit that the respondent was not a credible witness. And we say this in the light of the exchanges, but these were documents produced by the Judge Makhubele. In the light of the exchanges between various members of IBOC, as appear from pages 54 to 62 of volume 17, that's JM3, 10 to 18, it is manifestly clear that the request for a review of the opinion was not based on the so-called tangent that ENS was alleged by the respondent to have gone on. And again, we appeal to the tribunal's understanding of the probabilities. We look at the probabilities. What was happening in February 2018 in relation not only to what was happening at PRASA, but what was happening in the life of Madam Justice Makhubele at the time? We submit that Judge Makhubele must have felt beleaguered at that time, as apparent from the other communications which she relies upon. It is not clear who other than the Judge Makhubele herself would have required clarity on her position at PRASA. Unfortunately for her, the opinion did not suit her, and the opinion incidentally accorded with the opinion offered by the State Law Advisor, which was sought after Judge Mlambo had sent off the request that her date of assumption of duty be deferred. He used the word deferred, not that her appointment be revoked. He was quite clear on that. What emerges, I submit, from the acceptable evidence placed before the tribunal, is that the respondent understood that she had been appointed as a judge with effect from 1 January 2017. Her appointment was published, and we come to what the legal position is, in no uncertain terms on 2 November 2017. From that date, the respondent would be expected to conduct herself in a manner becoming of a judge. The Judicial Service Commission had made a recommendation as early as the 4th or 5th of October 2017. They had made it plain to the world at large that they were recommending Judge Makhubele, then senior counsel, as a judge of the High Court. That was followed up on the 2nd of November with a presidential appointment. There can be no mistaking that. Acting in terms of Section 174, subsection 6 of the Constitution, that Judge Makhubele was appointed as a judge. How clearer can one be? The respondent had the duty upon permanent appointment to immediately sever all professional links and organize her personal business affairs to minimize conflicts of interest, as required by Article 12 of the Code of Judicial Conduct, adopted in terms of Section 12 of the Judicial Service Commission Act of 1994. This she did not do. Instead, when it was obvious that she was on the brink of taking up an appointment as a judge, which constituted the pinnacle of her forensic career, she accepted a position at Prasa on the very day that the Judge President had issued his directive to all the newly appointed judges, being 19 October 2017. Having regard to the unchallenged evidence of the Judge President, it's our submission that Madam Justice Makhubele could hardly have been blind to the potential conflict of interest between her role as a judge in the Gauteng North Division and her role as chairperson of IBOC, given the number of matters which came before the court of that division involving allegations of corruption. Members of the tribunal will recall the evidence of Mr. Justice Mlambo to the effect that had he known that Judge Makhubele intended to undertake an appointment as chairperson of IBOC, it would certainly have affected whether she would, there would have been a recommendation that she would be a judge of the High Court. He expressed his disappointment that she had taken on this role at Prasa, given the fact that there was so much litigation. As a matter of interest, shortly before her, this is a matter of public record, shortly before her appointment, the Swifambo matter had found its way. This involving Mr. Mackenzie Mabunda had found its way to the High Court and was dealt with in the North Gauteng High Court.
Sorry, does it matter that in her evidence and maybe in a state of mind, Judge Makhubele testified that she thought it was going to be a short time at Prasa in October 2017 when she accepted the position. Number one. Number two, and the board to which she was appointed as chairperson was an interim board. Does it matter?
My respectful submission, Judge Moshidi, is that it doesn't matter. It's got, what should have mattered to her was the dilemma she faced. That was what should have mattered to her. But what was her answer when I cross-examined about that? She said, oh no, I had no security that I was going to become a judge. And that's when she referred to the failure of the president to appoint Judge Meyer as the Chief Justice, without regard to the fact that the powers of the president in respect of the two appointments are completely different. So, in my respectful submission, whether it was going to be a short appointment or a long appointment, she should never have taken that appointment, particularly at the point that she did. Please remember, members of the tribunal, she had already been informed by Mr. Justice Mlambo as early as probably the 4th or the 5th of October that she was a successful candidate right then. This was something that she had sought, according to her evidence. She wanted to be a judge. She didn't, somewhere within the record, she said she didn't want to walk around as counsel anymore. She wanted to be a judge of the High Court. So by the night of the 19th, having received the email from the judge president congratulating her and telling her that she must prepare herself to be a judge with effect from the 1st of January 2018. What did she do? She went the following day and accepted a job with an institution which litigated substantially within the division where she was to be a judge. And to that extent, we say that upon permanent appointment to immediately sever her links with and organize her personal business affairs, to minimize the conflicts of interest. A judge's job, I don't need to tell you two gentlemen, but a judge's job is almost sacred in a sense. One is removed from the dust and the dirt that affects ordinary people like us. You are, to some extent, to be above all this. And yet, Judge Makhubele saw fit to go and involve herself with an organization where there was widespread corruption. This wasn't kept under the blanket. This was public knowledge within the community and within the division which she had acted for 58 weeks. I submit that having regard to the unchallenged evidence of the judge president, the respondent could hardly have been blind to the potential conflict of interest between her role as a judge and her role as the chairperson of IBOC. Article 5 of the Code requires that a judge must always, and not only in the discharge of official duties, act honorably and in a manner befitting judicial office. And the question requires an answer is whether the actions of Judge Makhubele deserved respect in the sense that she conducted herself honestly, conscientiously, scrupulously, and in an upright manner. In this regard, we submit that Judge Makhubele's conduct fell woefully short of what was required of her. It must have been clear to her that she had a problem on the 19th of October, as she was in receipt of the directive of the judge president, and according to her version, the totally, and remember the members of the tribunal, totally unexpected announcement of her appointment as chairperson of IBOC. And instead of being upfront with the judge president in her email of the 20th of October by mentioning the Praza appointment as the reason why she wanted to delay the assumption of the office of a judge, she simply stated she wanted a discussion about the starting date. And we submit that she suggested disingenuously that somehow the directive had followed a few days after the Praza appointment, and when she met the Minister of Transport was not sure at that time whether she was going to be a permanent judge. And that flies in the face of the whole constitutional procedure. She was interviewed by the JSC. She was recommended. The judge president told her, we're waiting for your letters of appointment. They will come. You're going to start on the 1st of January 2018. How could she be misled? How could she have believed for 1 minute that she wasn't going to be a judge with the affair? This is the quality of the evidence which we asked you to consider. However, in her 4 December 2017 email to the judge, she was equally less candid with the judge president as to the true reason for her reluctance to commence with her duties as a judge on the 1st of January 2018. The so-called challenges she was allegedly facing could have been spelt out in no uncertain terms, which would have included mentioning her commitment to PRASA. She did not mention it. Why? Is this the conduct of somebody who's behaving, remembering what I said, honestly, conscientiously, scrupulously, in an upright manner, to the very man who had been one of her major supporters to push her to the position which she had sought and which she now was turning her back on? The two men no mention of the by the respondent that as early as June or July. Now, the evidence of Judge Makhubele underwent some developments. It wasn't mentioned right from the beginning, from the get-go, that she had this idea that she was going to start in April, and that it didn't suit her to start on the 1st of January 2018. So she made no mention of the claim that as early as June or July, she had made it clear to the JP that she would not be able to start on the 1st of April 2018, and that he'd agreed to such an arrangement. That was her evidence. So eventually, this is what we were told. We were told that, no, but this was already on the cards before she'd gone to the JSE. Now, one would have expected, if that in fact was the case, that it would have been mentioned in this email of the 4th of December 2017, but it wasn't. No mention of PRASA, because the tribunal will remember that she was telling Mr. Justice Mlambo all the time that it was the water board, it's the water, I can't do this. Mr. Justice Mlambo was saying, that's not a problem. This is a judicial function. You are able to attend to those matters. If you require time, I shall give you time. And then she stated, I wish to, then there's a letter. It's in volume 17 at page 347. It's a letter to the Minister of Justice dated the 13th of May 2018. And this is what she states. I wish to place on record that I requested a change of my date of assumption of duties from 1 January 2018 to 1 April 2018 as far back as November 2017. Now how does one marry that statement with her evidence which she gave before this tribunal, that had already been agreed to before she'd gone to the Judicial Service Commission, agreed to by Mr. Justice Mlambo, that she would only start on the 1st of April? Why didn't she tell the minister that we'd already agreed to it before in July? I'd agreed to with Mr. Justice Mlambo that it only start on the 1st of April. These are some of the concerns as to the consistency of the version of Madam Justice Makhubele before this tribunal, and which we urge the tribunal to consider in making a decision as to where the truth lies in this matter. The version tendered by the JP, as supported by the version of Judge Ledwaba, we say, accords with the probabilities. The Judge President had been made aware of media articles that the respondent had been appointed as the chairperson of PRASA, but had not questioned about her. The tribunal will remember that the Judge President said that he'd hoped that she would stop what she was doing. He didn't want to press her upon that point. The respondent gave evidence under oath that no such articles existed, thereby suggesting that the Judge President had falsely claimed that he'd read such articles, but had later retracted this claim. Matters came to a head when the respondent didn't turn up to take the oath, and we've dealt with that. And when she didn't assume office, the respondent responded that she was tied up with the water tribunal. And she persisted in that version, that it was just the water tribunal. We then submit that the conduct of Madam Justice Makhubele cannot be considered as honorable. She, in effect, made a series of misrepresentations which she knew to be false. In her evidence, the respondent made much of the level of trust to be expected of other officers of the law in the context of her dealings with Boerters. Her omission to inform the Judge President of the true reason for her reluctance to commence on 1 January 2018, we submit constituted a serious act of misconduct, no less serious than an officer of the court making a misleading statement before a court of law, which he knows is not entirely true. Now, to exacerbate matters, when pressed by the Judge President to desist, Madam Justice Makhubele declined to do so, stating that she did not want to disappoint the minister. Now, again, why would the Judge President, supported by what Judge Ledwaba was prepared to depose to in an affidavit, make up this, that she didn't want to disappoint the Minister of Transport? Interestingly, from her own evidence, right at the beginning, when the water board issue was raised, one of the reasons for her reluctance, according to her, not according to what Mr. Justice Mlambo said, was that the minister had appointed her for 4 years. She'd only undertaken 2 years. And she didn't want to leave the minister in the lurch again, because there had been problems previously with the chairperson of the water tribunal leaving prematurely. So that was a minister and a member of the executive, bearing in mind the concept of the separation of powers. So this was a minister that she didn't want to disappoint. She said, I'd love to be judge, I want to be a judge, but hang on, I need to sort this thing out with the minister. But then the respondent has not in so many words accused the 2 most senior judges in the division, which he had appointed, of perjuring themselves by testifying that the meeting at which the exchange took place, allegedly took place, did not happen. The exchange relating to that she didn't want to disappoint the minister. It is instructive to note, and the point we make, that the readiness with which the respondent was prepared to serve the executive as opposed to the Constitution is manifested in 2 other instances. According to the respondent's own evidence, despite the Judge President's assurance that there was no conflict of interest between her duties on the Water Tribunal and the office of the judge, she did not want to let the Minister of Water and Sanitation down by resigning prematurely. Then the respondent caused this WhatsApp to the Judge President on the 4th of April 2018 to be placed before the tribunal. It's in JM2, volume 21, pages 31 to 34, which contained the following statement. As I reported to you and DJP Ledwaba, I met and discussed the matter with JB at their parliamentary office in Cape Town on 7 March. I only learnt on 6 March from Minister Masuta that he and former Minister Maswanganye discussed my continued stay at Praza, and they agreed that the former should let me go. Minister Masuta, as cabinet minister, is part of decision to appoint the interim board. I don't want this matter to go to an extent where he will be forced to disclose the discussions at cabinet level between him and Misconduct. And I want to emphasize what follows now. I sent Misconduct a note on 8 February and advised him that I'm resigning with immediate effect. He pleaded with me for time to advertise vacancies. He was removed just before the closing date of nominations, and Zimande re-advertised after his appointment. This is one of the reasons why I resigned earlier than end of March, because I realized that the politicians don't want to address the issue of the status of the interim board, while I continued to be, I emphasize this, battered by the media. Now, just to remind you about the facts. The 8th of February is quite an important date, because it was about that time that Mr. Justice, well, it was the day after, Mr. Justice Brunt had made the settlement offer, which will become critical to the next part, had made the offers awards in respect of the 4 summonses, the awards. That was done on the 7th of February 2018. This is now the 8th of February 2018, which she reports that in this WhatsApp to Mr. Justice Mlambo, she reports that on the 8th of February, she sent the Minister of Transport, Misconduct, a note to say she wanted to resign then. And he said, please just hang on, don't go yet. So our submission is that at a time when she was a judge, the civility with which the respondent displayed towards members of the executive branch of government is astounding. The quotation supra resonates so completely with the evidence given by Mr. Justice Mlambo of the meeting in the middle of January that the respondent was reluctant to leave Prasa because she did not want to disappoint the minister. Now, how could Mr. Justice Mlambo have anticipated that she would be writing a letter to the Minister of Transport saying that she wanted to resign? That's in February. There can be no doubt that the first complaint raised by the complainant is justified on the evidence raised before the tribunal. In the light of the conduct of Madam Justice Makhubele, this tribunal ought to find in respect of the charge that she held an office for profit as chairperson of IBOC while she was a judge in active service. And she was in active service at the time. She wasn't in receipt of a salary, but she was a judge in contravention of Section 11(1)(a) of the JSC Act. We submit that the aims and objectives of the JSC Act was to regulate judicial conduct considering the overriding principles of openness, transparency, and accountability that permeate the Constitution that are equally applicable to judicial institutions and officers. We then deal with Section 1771 as to what the powers are of the Judicial Service Commission and further, so if I may move on, further disturbing aspects of the conduct of the respondents as revealed by the way she conducted herself at the tribunal may be set forth as follows. We say that the respondent failed to grasp the challenge which she faced in explaining away why certain vital instructions were not put to witnesses by her counsel. She claimed that it was the responsibility of erstwhile counsel to explain why her instructions were not put. The inference, and to come back to the question I was asked earlier, is inescapable that she had not told her counsel to contest vital aspects of the evidence adduced against her. She was seated next to her counsel, a very senior counsel, throughout the proceedings when witnesses were led. And there were several instances when the matter was stood down or was adjourned, during which time she had ample opportunity to instruct her counsel. Her version was a belated attempt to explain away the evidence which was against her. Equally belatedly, she resorted to the claim of attorney-client privilege, which was absolutely no bar to questions being asked in cross-examination as to whether she had instructed her counsel. We also point to other aspects which I don't plan to deal with now. We submit that by implication, the respondent attacked the integrity and honesty of two senior judges with whom the respondent worked, not because they're not to be believed because they're senior, but we submit that their evidence was credible, or the evidence of Mr. Justice Mlamba was credible, supported as it was by the affidavit submitted by Mr. Justice Tintswalo. The respondent resorted in our respectful submission to an unfounded attack upon the honesty of these two judges to extricate herself from the mess which she had caused, and this conduct was incompatible with or being unbecoming of holding a judicial officer. And we submit that on a conspectus of all the evidence before the tribunal, in regard to the first complaint, the respondent was guilty of gross misconduct, and at best for her, she was shown to be grossly incompetent. I don't know whether this is an appropriate time before I... To the second complaint. Thank you. Thank you, Mr. President.